I'm requesting that we take our seats. We should be starting our program. So I request that we get seated. Thank you. We shall start with a prayer, and may I invite Your Worship Jamgish from the Family Division to come and give us an opening prayer.
Thank you, Your Worship. Good morning, my lords, Your Worships, accredited mediators, and all invited guests. Let's humble ourselves and pray. Heavenly Father, we want to thank you for this morning. We thank you for bringing each one of us to this place. We thank you for the journey mercies. We thank you for our families. Lord, as we are going to deliberate on this very important topic on validating the draft mediation rules, which are intended to enable the revamping of mediation in the judiciary. Lord, may you come and be amidst us, guide us, give us wisdom, give us good ideas to enrich this draft for the good of the mediation scheme and for the good of the judiciary and administration of judiciary. Guide those who are on their way coming, hasten their steps, and Lord, when we're finished, may you lead us back to our destinations. I've prayed all this believing and trusting in the name of Jesus Christ our Lord. Amen.
Thank you very much for giving us that prayer. My Lord, the chairperson of this morning session, my Lord, Principal Judge Emeritus, my Lords, the Justices of the Supreme Court and the Court of Appeal, my Lords, the Judges of the High Court present, my Lord, designate the Chief Registrar, all our distinguished guests, registrars and magistrates present, I would like to welcome you to this session of the validation of the Judicature Court Annexed Mediation rules. My Lord, we have a brief program which I would like to take us through. My Lord, we are done with the prayer, and we shall be having welcome remarks by the Honorable Chief Registrar. who will after invite you, my Lord, to make your remarks as the chairperson of the Law Reform Committee. Thereafter, we shall have an overview of A, the draft rules, B, accreditation of training institutions, C, accreditation of mediators, and D, code of conduct by our distinguished presenter, Senior Counsel Francis Jimara, who is already with us. My Lord, after that we shall have a tea break and we shall return for plenary and a way forward. That shall be followed with lunch and departure. My Lord, I'd like to inform you that we have 7 participants online who will be following the proceedings of this session this morning. With that, my Lord, allow me to invite the Honorable Chief Registrar to come and make her remarks. My Lord, you're welcome.
Thank you very much, Your Worship. My Lord, the chairperson of our session this morning, allow me to stand on the protocol that was laid out by the PRO, our moderator this morning. And my task is simple: to welcome all of you, my lords, and the participants, and to thank you for sparing time amidst so much of the competing priorities that you have. My Lord Chair, allow me to apologize to members that the notice was rather short, but it's because of the many competing activities of the quarter, and yet the validation of these rules is very important, as it is part of the rules that are scheduled to be considered by the joint retreat of the Rules Committee and the Judiciary Law Reform Committee, who will all be meeting on the 4th and 5th of next month. So it was important, as we all know, that given that we are in the season of revamping and re-engineering mediation, everybody has been concerned about the review of the 2013 rules. And so it was important that this activity happens so that we put it on schedule for the retreat, and the same gets gazetted so that we can safely use rules that speak into the new season of mediation that we are dealing with. My Lord Chair, allow me to also use this opportunity, being that it will be my last, God willing, to stand here as Chief Registrar, to really say a big thank you to all the members for the support they have given, particularly to the Law Reform Committee in the making of so many rules in the last 4.5 years that have been Chief Registrar. Thank you so much, my lords, for your support. Thank you so much for your very invaluable contribution to the different rules and practice directions that have been developed over the years. I now wish us all the very best of today, and I pray that the good Lord will continue to watch over all of us. My Lord, with that, I say thank you once again, and I now invite you, my Lord, to make your remarks. Thank you so much.
Thank you very much, Chief Registrar and my Lord Designate, my Lords, Your Worships, ladies and gentlemen, good morning. And thank you very much for coming. I thought we had outgrown the habit of leaving the front seats empty. And you are all big people. I cannot say, okay, everybody now move to the front. I'm tempted, but I will not do it. But there are no other higher people than you who we are expecting to come and occupy those seats. So at your own leisure, when you feel led, please move and occupy the seats reserved for you. Secondly, I would like to communicate that I'm standing in for the Honorable the Principal Judge, who is the chair of the Law Reform Committee. He was not able to be here with us this morning, so I am I'm acting in that capacity to chair this meeting. Thirdly, I would like to congratulate those of you who have been elevated, starting with so you know we are now in between titles. You are still Chief Registrar, but you are our Lordship designate. So we want to congratulate you. We want to congratulate His Lordship Musa Sekana. You are all wished the very best in your new assignment. And I would like to welcome especially our court accredited mediators, starting with Principal Judge Emeritus and my lords. Yes, let's give him a welcome. And my lords, they are seated together. Reminds me of the Three Musketeers. But my lords, it is always very good to have you and for you to be part of this. We are here for a simple program. It is to validate the draft Judicature Court Annexed Mediation Rules 2025. And what is validation? Validation just means that there was a committee, the Law Reform Committee, which came up with the rules and worked on them. And within the committee, they felt, I think we've done enough and the rules are good to go. But we know that you can never be sure about the meal you have prepared until some other people have tested it and said it is good. So we have invited you and carefully chosen you to be able to test these rules that were worked on by the committee. In other words, you are the practitioners, the consumers, and the people who will be able to say, okay, this one is okay, this one we need to add something, and so on. So your role today is really to help us go through these rules as they will be presented by Senior Counsel Francis Gimara, President Emeritus of the Law Society. And we think this should be done very quickly because we are not beginning from scratch. With those few words, I would like to welcome you and wish you very fruitful deliberations. Thank you very much. I hand it over back to you, Pierre.
Let us give another hand clap to the chair for inviting us to the front seats. My Lord Chair, those front seats could be occupied by our guests online. So we want to think that they are seated right there and the others will join. Thank you very much for those wonderful words, my Lord. And allow me at this juncture, my Lord, to invite our facilitator this morning, Senior Counsel Francis Gimara, to take us through the much awaited discourse on the draft rules up to the Code of Conduct. You're welcome, Senior Counsel. Let us welcome him.
My Lord Chair and PJ Emeritus and my Lords, Justices, Judges, Your Worships, and indeed allow me stand on the protocol as earlier established. My duty this morning is to present, just like the chair has ably articulated, the outcome of a consultative process that now has draft mediation rules. But for many of you, you will be happy to note that this process has been a work in progress. You recall when the court annexed mediation started, there was even a discussion that we start with some ad hoc guidelines. Now, most definitely, that did not take root. The preference was that we now actually develop the rules and the lessons that the court annexed mediation, the one that was relaunched that the CR has spoken to, have largely formed what the Rules Committee and the Judiciary ADR Committee has been working on. So the committee definitely would like to reiterate that the process of doing this systems reform, we call it a systems reform because the rationale is much broader. Part of it is to cater for recent developments in the space of ADR, recent developments both at the international platform. We see an increasing recognition, or if you would, increased uptake of ADR as a preferred mechanism of resolving disputes for advantages that we all know. There are new international frameworks that have since, been rolled out. The latest, which is catching fire, is the Singapore framework for international mediation. And that is now informing a lot of developments in that space. When you come back home, Cabinet last week did roll out or pass the ADR policy. That ADR policy is intended to inform several reforms. And I think I read the newspaper yesterday that the president was very happy that the judiciary is actually thinking in these terms. So it's not only at the executive level, but also the users are beginning to say, well, litigation is there, it has to be there, it has its role, but also ADR should be used to help or support some of these processes of justice delivery. But also another rationale for this is the need to cure the defects of the 2013 mediation rules. The 2013 mediation rules did learn from the rollout at the commercial division, but we all know that it had a lot of challenges in terms of conceptualization, in terms of implementation. Eventually, the 2019 amendments to the civil procedure rules abandoned the compulsory mediation framework by requiring the process to go through a certain level of detail. So since then, there has not been that mandatory filing of mediation files. And we then now come to this place where we are at, the court annexed mediation. Then, of course, the rules have also been informed by the need to cater for innovations. I think world over, people are talking a lot about virtual ADR, virtual mediations. So I think the framework for that has to be provided for. Then, of course, what also came up in terms of the reforms were the whole issue about performance enhancement and improvement. Court annexed mediation has come, but how do you ensure that the performance of the mediation is enhanced and as well as monitored? Then the whole issue of standards, the rollout was very well received, but the standards were different. we don't have a place where registrars or those in charge of mediation would look at for uniform application or management of a mediation file. So there was a need that we design a system that provides for uniform standards, so that when you're in family division, as a deputy registrar in charge of mediation, you know what to do. If you are in the High Court of Moroto, the standards should be similar. The court annexed mediation, when it was rolled out, a lot of it was left for each court to innovate in a way that they wanted to. Then, of course, now that we have those learnings from the court annexed mediation, it's important that we do them. Also, in opening, let me underscore that today when you are speaking about any reform, there is what the experts have been rolling out, that you have to think in terms of systems. What is that system that you are reforming? Where is it broken? What else do you need to do so that you holistically fix the issue? And the rationale here is very easy. You may fix the rules and you don't fix the issue of conduct of mediators that may be able to affect the rollout of mediation. So when you think in systems, you begin to look at matters holistically, because a system is basically a setup of interconnected, a setup of interconnections organized to achieve a purpose. And in that book, one of the experts, Donella, says that there provides some guidelines which the committee found very useful. And some of these guidelines were, understand system boundaries, where is the relationships when we are doing mediation between the formal court system and mediation, what are the boundaries there? Define those, ensure that you focus on feedback loops. At the end of the day, the judiciary is in a way delegating the justice mandate to mediators. But you need some feedback loops always to ensure that the systems are speaking to each other, that the behaviors under the mediation system espouse what the judiciary would like to see. Then, of course, also the guidelines in terms of systems thinking require you to seek root causes. What are the underlying structures you want to fix, rather than treating symptoms? The 2013 rules were treated a lot of symptoms, but left many things hanging. For instance, the attitude and speculating or providing for the role of advocates was not very clear. And like we always say, that when the rules came out, there was no rollout, there was no enough discussion with advocates. So many times an advocate who had been schooled in litigation would basically just show up before a mediator on day one and project to the mediator that my instructions are that you close mediation and send back the file to court. And I think 70% of the advocates did that. So with that kind of thinking, definitely mediation was not going to take off. So in trying to think systems here, we are also addressing that issue. How do we address that issue? Then, of course, time lags are important. You don't want to create a mediation system where then matters delay and the public begins to look at mediation as a form of delay in justice delivery. So you need to speak to timelines, you need to address issues of time lags, and then you use models. So the systems also thinking also requires you to pick some models and use. The model that we thought would work for us is the McKinsey 7S models. The 7S models, you are looking at basically the hard S elements and the soft S. You are looking at shared values. What are those values we want to achieve? What is the foundation driving us to try and use mediation? What is the mission? The vision of the judiciary is that justice is for all. And the reports indicate that many people prefer to have these conversations. You need to think about those shared values. Because if your value is justice, and then the people also are saying ours, we also want to see justice, but also accommodate us in a manner where the judiciary begins to understand how we would like to resolve disputes. It then becomes very, very important. So this McKinsey 7S framework became very important to help us to think holistically. The first S is values, then also it helps us to think about the structure. What structures do we need to see going forward? You know, are we organized? Do we have a sufficient chain of command and accountability relationships to help support mediation? Then what is our strategy? What do we want to achieve? You know, at the end of the day, that is very, very modern. A plan of action, we have obviously the Judiciary Action Plan, which would like to see many cases dealt with, would like to deal with case backlog. So this strategy of mediation must help us achieve what we have all agreed collectively in the Judiciary Strategic Plan that is important. Then, of course, I've spoken about the workflow, the systems. The workflows must speak from the time a matter is filed, at what stage do you deal with mediation. That is also important. Of course, the skills are important. That's why we are now speaking about accreditation. What kind of mediators do we need to help this? Are they able to resolve disputes? Do they have the skills? What kind of training should they have? Then, of course, the style is very, very important, because the style, to have a consistent style of mediation. Like we said when we rolled out the court annexed mediation, we didn't have style, if you would, culture. But these rules, this framework, is to support us to have a style of mediation, and that's why we are calling it court annexed mediation. Then, of course, the staff, what skills, the human resources required is very critical. So with that model, with that background, with that rationale, and with systems thinking, the committee came up with about 7 things that are important, in our view, that we should think about. Next slide. The key documents that we thought are important to enable us address those 7 S's, but also to help us resolve the aching issues in mediation, have now been formulated under those 7 key documents. The first, which we'll look at today, is the Judicature Court Annexed Mediation Rules. And the language here, unlike before where we are speaking about judiciary mediation rules, we are saying court annexed mediation. And court annexed brings a certain limitation to the type of mediation that you want to pretend over. Then we're also saying there are so many training institutions today, doing mediation. What do we need a training institution to do so that the chief registrar can recognize the persons they have trained as court accredited mediators? So that's why the relevance of the mediation training institutions guidelines become important. Then, of course, there is accreditation of mediators, which the chief registrar does. But those guidelines are to support this process for anyone who wants to be a mediator to address to the requirements therein, and then make the appropriate procedural dues that are necessary for them to be recognized. Then also we are saying this time we need to have a code of conduct in place, because these mediators are annexing themselves to the courts of judicature. So the way they mediate matters, what they do, is of public interest now. So a code of conduct then becomes very, very important for every mediator to understand and to live by. Then those are not only the only documents. We also saying this time performance management is important. If you have been appointed a court accredited mediator, and in a year you have not done any mediation, the question should be, should you remain a mediator? So performance becomes very important because the judiciary is rolling this out to deal with case backlog. So the urgency for a mediator to deploy themselves to the assignment is critical. So if you are going to delay the matter for 6 months and then it comes back to court, it will worsen the case backlog. So that's why performance management becomes important, because you want public buy-in. For people to say, yes, mediation is working. I actually had my dispute resolved in under 1 month, in under 2 months through mediation. That is the kind of success story that a successful mediation system should be able to articulate to the key stakeholders. Then to, of course, ensure that performance is managed, you need an oversight team. So there is an oversight mechanism that has been developed. Then, of course, we are also saying a handbook and registrar protocol on court annexed mediation to support the registrars and the magistrates doing that. With that in mind, my lords, my ladies, allow me touch on the most important of all these, highlights of the court annexed mediation rules. And I will begin by highlighting the key objectives of the rules. One is to provide a very clear definition of court annexed mediation. Now, this is to separate it from the other mediations. Court annexed is court-managed mediation, if I may use that language. So we would like that definition to be understood, and the rules this time brings it very clear. And this is a mandate, definitely, that the judiciary has. Then the other objective of the rule, like I've highlighted, oversight and administration. Then we also are seeing this time that we are broadening the scope of mediation. Based on the thinking, we are saying that you can also mediate before you initiate a matter in court, and this is in respect to the agreement of the parties. If you say, let's do a mediation, this dispute has arisen, or even in contracts today, it should be very normal for lawyers to craft dispute resolution clauses in contracts that they are drafting to provide that we will, instead of filing in court, resolve this dispute through mediation by a court-accredited mediator, and then we will file whatever outcome from that mediation in court for enforcement. That is what we are calling pre-litigation mediation. Then, of course, pre-trial is before hearing. And then, of course, now the rules are making it very clear that at any stage of the hearing, a matter can be referred to mediation. Then, of course, appellate mediation commenced before the legal framework, and people who are on my side are always saying, where is the law for appellate mediation? What the court is doing is without basis. So those arguments have become very loud in the area I work in with my stakeholders. Now we are responding to that argument by saying, let the rules provide for appellate mediation as well. Then oversight, but also this time, we are making it clear for the parties to understand their roles. And we will see later on that we want to give the party their rightful position to be the driver of mediation and the lawyers to assume an advisory role. So we are stipulating that clearly in the rules so that the lawyers understand that when it comes to arguments in court, I plead my client's case. But when it is mediation, I support my client to communicate and negotiate with the other side with support of the mediator. Then we're also saying that since this is court annexed mediation, we are dealing with matters filed in court. The immunity must be extended to mediators, just for that purpose, when I'm dealing with a file referred to court, I must not be sued as a mediator in my personal capacity, just for court annexed. Then remuneration, to make it clear, the 2013 rules didn't have anything on that, but we have now something to do with that. And then, of course, another objective is to provide for accreditation of institutions. The scope I have already highlighted. To any lawsuit or appeal, but under pre-litigation, we are dealing with what you call voluntary mediation, the choice of parties to have their matters mediated as opposed to litigation. The choice of parties as well to benefit from the execution framework of the court. If they so provide for it in the agreement, the rules are saying that should be okay, we will accommodate that. So that is what is called pre-litigation mediation. Then pre-trial, that is when the matter is filed before a hearing by the judge to render a decision. And as we will see, that is through and through. Then I have already highlighted mediation during appeals. Now, appeals here is general. It also includes appeals that the High Court may be handling, not only the appellate, the Court of Appeal, but also just any court having appellate jurisdiction as empowered by law. So the rules provide a very clear process, key steps, how the matter is referred to mediation. If you look at them, they are referred by judicial officers. At first, there was a requirement that the judicial officer must screen the cases and determine whether they are suitable for mediation. But the law reform meeting last week, the feedback we got, the committee, that we are going to create a drug. Remember systems thinking. You know, you are now going to give power again to a person to determine, and that person may not move with speed. So the suggestion was that we drop the screening requirement and we move for a referral of those matters. Then, of course, appointment of mediators. Then of how you notify. There has been a challenge about notification of mediation, but you'll see in the rules, the judicial officer, 7 days must notify the mediator over that. But also, the parties have been given the liberty to initiate communication with the said mediator designated by the court within 7 days after the designation. And again, here we are bridging time. We are just saying in case there is a lapse and the matter has not been originated, the parties can proceed and make that referral. The sessions should be conducted within 60 days. That was the same in the 2013 rules. That has been retained, but we are also saying that time can be extended. Today, you can have a mediation for public policy disputes. These ones are complex. They may be infrastructure disputes, you know, over maybe a new project. Those may not take 60 days. Those may take a lot of time. But we are saying after 60 days as a mediator, if you have not been able to finalize, ask for extension. But the courts must manage the time. So that time, again, is a matter of urgency. You have 60 days, conclude. But if for any reason you cannot, ask for extension. Then, of course, we have clarified on participation and as well as settlement agreements at the end of it all, how they should be like, including the standards. Steps, moving on from referral, appointment, commencement, scheduling, moving on to conduct, and then how it ends with progress reports. Then let's look briefly at the oversight. There is now the Judiciary DRA Committee has been around, but now they have a very clear mandate in terms of superintending over mediation. have an oversight mandate on policies, rules, and guidelines, improving the effectiveness. They also supervise mediation generally. They have a quality assurance mandate, and as well as mandate to handle complaints and disciplinary actions against mediators. They have an accreditation and training mandate to ensure that this mandate is not to train generally mediation, but if it is court annexed, then they are involved to see that the training meets the objectives of the institution. But they also have an administration mandate to collect data and forward it to the Chief Justice, as well as to ensure that mediation is integrated at all levels. Then we have clarified as well the responsibilities of judicial officers in charge of mediation. We are emphasizing mediation registries and the need to ensure adherence to timelines. Of course, they also process claims for payment of mediators, but also those private settlement agreements I spoke about, the pre-litigation ones, their registration and enforceability. Then, of course, periodic mention of matters, coordinating the matters with mediators and the court. The matter is concluded, no successful mediation, you bring it back to the judicial system. Or if the judge needs to sign off something, that we have now provided guidance, and also allocation of matters to mediators. Now, the roles and responsibilities of mediators. Again, for clarity, what they need to do is very, very clear, to resolve and facilitate resolutions of disputes in good faith. And then the golden one, maintaining confidentiality and impartiality at all times. And there are also duties now. You know, they prepare attendance lists, submit mediation reports, as well as facilitate settlement agreements. Then, of course, compliance with timelines that court has issued. Those are now very clear. The parties, we have also provided for their duties very, very clearly. They must attend in person to the greatest extent possible. But if you are going to authorize someone, we have also created a form where you sign and authorize that person. Why? You don't want the person who has been authorized to lead the mediator to a settlement, and then when it is signing time, say, I don't have authority. You know, that will be wastage of precious time. We would like to deal with that situation to ensure that that wastage is avoided. So if you are authorizing somebody to mediate on your behalf, they must as well conclude on your behalf. If you have got to consult them, but come back for closure with the power to close. We're also saying the same with the Attorney General, that they should look at the system in-house, and then when they assign a state attorney to mediate, it should also come with instructions to bind government. And that form has also been prepared. Then, of course, to observe rules of engagement and sign confidentiality agreements and settlement agreements. Advocates, to cure 2013 problems, we are putting a role for advocates so that they understand what their role is. We are saying their duty is to advise parties in mediation. You retain your duty to be counsel to the party. But unlike litigation, where you speak, you take leadership, we are saying allow the party to take leadership, support in the capacity of advisory. So as we do mediations moving forward, we need to educate lawyers about their roles and also help to get them out of that litigation mode that I must always be the one speaking. This is a party-led initiative, and it should remain so to the greatest extent possible. But we're also saying, don't just say, hey, lawyers, you lawyer, get out. I only want parties. No. If a party is comfortable with their lawyer there, let them be there. But you, as a mediator, you need to have the skill to open up with the parties to the greatest extent possible. Even just asking the party, can I caucus with you alone to try and understand them? Because some lawyers come with a very vested interest in the dispute, and they own sometimes the dispute, and when you own the dispute, you lose objectivity. You just want to litigate and you want to be in charge. So we are clarifying the role of advocates so that it is understood, and also that it will facilitate a re-education to onboard many advocates as well. Thankfully, since the court annexed mediation, we are seeing a change of attitude. So it is possible that salvation will come in those terms that we have listed in the rules. Mediation registry operations, because mediation is a secretive, confidential process, we are requiring that the registry operations be maintained or set up in a manner that facilitates the principles of mediation. Confidentiality and admissibility, that's something that is very, very important. We are saying, emphasize to the parties over and over again that this is confidential. This, whatever we discuss under mediation, is inadmissible to court, and also breach of confidentiality may constitute contempt. But this time, from 2013, we are also introducing some consequences for non-compliance by parties. Because this is court annexed mediation, the judiciary is spending a lot of resources to roll it out. It cannot be just an activity. So mediators should notify the court of non-compliance. And sanctions for non-compliance we are providing for them, including parties to attend further sessions and pay costs as well. So the mediators now will be able, when a mediation has concluded, to file a certificate of non-compliance and disclose why it has not been successful without details. But this is for the courts to determine whether they issue sanctions or not. And if the rules provide for them, then it should be able to be done. So how do you conclude mediation? The rules provide for that. The place of settlement agreements, and the rules are saying these are binding and enforceable as court orders. Partial settlements have also been provided for, but also clearly there will be no appeal against those orders arising from settlement agreements. And then a time element as well, the mediator to submit a report 10 days after closure of the mediation. Again, we go back to systems thinking, time becomes important. That the train of mediation runs in accordance with required timelines. Now, of course, mediation comes to an end upon filing of settlement agreement or a non-compliance report or expiry of 60 days, unless, of course, extended. We've provided limited grounds for setting aside settlement agreements. Fraud, misconduct, those are just like any settlement agreement. When you set it aside, we have replicated those grounds, and then also clarified on mediators' fees and how they are done. In conclusion, as far as these rules are concerned, let me say that they aim at streamlining and enhancing mediation within the judiciary. They provide a clear framework for processes, roles, and responsibilities. And we would like to state that they are very cardinal in improving access to justice and as well as reducing case backlogs. The overall effect of the mediation rules is to revoke the 2013 rules and replace this with 2025 rules. So I will highlight the others are very short. Allow me just go to the next set of slides. I'll just highlight them and then we'll open up for discussion. the code of conduct for mediators. You realize that we did not put principles. You see that in 2013 rules, we put principles of mediation in the rules. But this time, we have improved on the principles and located them in the code of conduct. But the rationale of the code of conduct is again to ensure professionalism, impartiality, honesty, and confidentiality in mediation. But also, importantly, and I can say this again and again, maintain judicial integrity and public trust in the process. Because you have many people who are not judges going to participate in court annexed mediation as mediators. So whatever they do must promote public trust in the process. And that is why a code of conduct becomes very, very critical. But also ensure ethical and professional mediation, but also to ensure that there is adherence to natural justice, equity, and human rights. Application of the code will apply to all court-annexed mediators in Uganda. I think the word there should be court-annexed. It's a minimum conduct, meaning that you can go above it, but it's the minimum conduct required. What are the guiding principles that are required for a mediator under the code of conduct? Key is self-determination. Allow parties to make voluntary informed decisions. Even when the matter is court-referred, you have got as a mediator to emphasize a buy-in from the parties. So self-determination is very, very important. So we are saying even if the lawyer is taking a lead, what is critical is that there should be voluntary informed decision-making. Impartiality is very important. Conflict of interest, avoid or disclose at the beginning of the mediation. Disclose any conflicts or any perceived conflicts of interest. You would like the parties to trust the mediator that he will do the mediation without an attachment to any conflict of interest, wherever it is located or perceived by the parties. Then, of course, we are saying that sometimes lawyers will be involved in mediation. Don't undermine a mediation and then you turn back and ask for instructions. Can you instruct me? Your lawyer is not going to manage this matter. He's a very weak lawyer. You know, now that the mediation has collapsed, why don't you instruct me? We are saying no. A mediator shall not establish a professional relationship with any of the parties as far as that matter is concerned. You need to be independent. You need to remain impartial. You need to play above board. Then, of course, commitment is very, very important. We don't want this to be a title on a business card. Court-annexed mediator would like you to do work. Would like you to do work, so your commitment is important to the process, but also throughout the end. Then, of course, non-disclosure and confidentiality, that is always going to be a key principle in mediation. You must be fair, ensure a fair and transparent process, and then mediator competence. You require to have a certain level of competence. I have found that in many mediations, when the parties believe that the mediator is competent, the degree of resolution of the matter is very, very high. So even when you start as incompetent, begin to grow your competence as a mediator. Have the necessary skills and experience. Decline a case if it is beyond your competence. If you're a mediator in commercial court and the matter is very, very heavy on intellectual property, and you don't know what a copyright is like, you know, and you're mediating the matter, it is important at that stage refer it to a mediator who has an at least understanding of the intellectual property dispute. Because when the parties are explaining to you and saying, but this has infringed my copyright, and the mediator saying, copyright how? I don't understand what you are talking about. What's a copyright? People switch off. And when they switch off, they will not resolve the dispute. So it's important that the mediator competence, especially for court annexed mediation, you need some basic competence in that court. If you are in family division, know at least the authorities, know the Supreme Court guidance on matrimonial property. It will help you do well. So that competence is important. Okay. Enforcement, of course, the Judiciary ADR Committee will enforce the code. We have provided for what amounts to minor violations that can be resolved informally through guidance, and then what amounts to serious violations. How you file complaints by stakeholders, if they are dissatisfied, the process has been provided for. The process itself, procedure, is all there, including outcomes, which may include suspension, removal, or other disciplinary measures. We will look at accreditation of mediators' guidelines. Why are we having accreditation of mediator guidelines? That's going to be the big question. These are just guidelines. And we are saying that if you are going to be a court-annexed mediator, at least the training institutions that are going to offer these courses, for us to admit a person as a court-accredited mediator, at least have some, let's recognize you. It's not taking away a mandate of any institution, by the way. This is just tied to court-annexed mediation. And this has now been mandated by the ADR policy. Strategic objective number 5 of the new policy approved by government says that, training the institutions will be able to train competent dispute resolution providers so that they support the resolution of disputes. Accreditation committee will be there, of course, for that. The committee will have a membership, and the scope of operation of the guidelines will be accreditation of, there will be institutions, and then, of course, accreditation of mediators. Standards, what are the standards required? Then education and training, and then how do you apply? Today there are many people who want to apply to do training. How do they deal with that? Then, of course, there will be a requirement for continuing education, and that also is being provided for, and of course the registrar. So we are dealing with 2 things here. That's one framework for accrediting mediators, and the other one for accrediting training institutions. Now, in terms of mediators, there's also a requirement to at least do some CLE, or continuous professional development, as a mediator. Why? There are many trends that are happening in the world in this space. And I think it's the good book that says, even if when you are learned, behave like you are still learning. It will do you good, okay? So having some 20 hours every year is not too much for you to be a court-annexed mediator of learning. And again, those guidelines are being provided for. And so there are 2 things here, accreditation of mediators and accreditation of training institutions. For that, I think we have looked at mediators. I've highlighted that. The slides have been a bit slow. I am very ahead of them, but I will be able to abridge. And so when we're dealing with training institutions, we are talking about just court annex, and that's the point I want to make. It's not mediation generally. It's just about training institutions. If you want to train people who will apply to become a court-accredited mediator, what do we as a judiciary want you to do? That's the essence of these guidelines of training institutions. And under that, we're making it very simple. Just have basic things. Let's look at your institution. Let's look at your experience. Let's look at your standards. Let's look at your program. Let's look at your workshops if you want to do CLEs. And the international requirement for you to have a basic qualification as a mediator is 40 hours. You know, at least basic, you must be trained for 40 hours. So we are saying, if you are going to have a training institution and you want us to recognize that training, at least to start with, know what we want. We are aligning with the international requirement, at least have the mediation training for 40 hours. And that is provided for. The course requirements, at least to see who is training, who is in your faculty, that's important. So they just submit an application to the committee detailing CV, trainers, facilities, and ethical policies. The committees may conduct a site visit, they may not. But if they see that these ones can train, it is an administrative thing. Upon confirming that the institution meets all the requirements, the committee will give you an accreditation certificate. This is not like an academic recognition that the National Council for Higher Education is mandated to issue. We are saying that we have a mandate as a judiciary to do court annexed mediation. And this is the type of people we would like if they are going to apply. But having said that, the judiciary will continue on its own to organize and train people to become court accredited mediators through the JTI and other systems. So other aspects of the guidelines, of course, is monitoring, collaboration with judicial bodies, and of course also working together with JTI and other judicial bodies to design mediation programs. So I'm going to stop here and ask for any questions on those 4 things. The mediation rules or comments, because this is really a highlight, but the rules were shared, and it would be very important, Chair, that we receive as much input from the stakeholders. So allow me end.
Thank you very much. Let's give Emeritus a round of applause for a job well done. But I think the Master of Ceremonies was whispering that you are taking over his job. So let's hand it over to the Master of Ceremonies today.
Thank you very much, Chair. And I was really worried that I might be out of the job. Thank you, my Lord. We shall be having a full hour dedicated a plenary where we shall have all these comments and discussions. For now, my Lord, allow me invite you and our invited guests for a cup of tea.
Thank you. How long is the tea break?
The tea break, my Lord, is just 30 minutes.
Okay, thank you.
Yes, my Lord.
Okay.
So I request that we move forward. the more we may be doing a disservice. We are moving forward to the plenary session and the way forward, and I would like to invite the chair of the session to take us through this moment. Thank you, my Lord.
Thank you. Thank you very much, Master of Ceremonies, my lords, worships, ladies and gentlemen. Welcome back from the break. In the next 1 hour, we are going to have reactions, questions, comments, and to the documents that were presented by our presenter. The way we are going to do it is we are going to look at document by document. We are going to begin with the rules. And I will ask that we take about five interventions, then we'll allow responses. I see, let me take the 5 at a go. I see Lordship Madrama. If there are no 5, I see somebody at the back. Okay, Country Director, IDLO, Barbara Clay. I see my Lord Worship Edoku, those are 3. Lordship Mliagonja. I think Professor Kiap used to say Mliagonza. Yeah. So the 5th one. Okelo, he still says the same. Okay, let's take those 4. Let's do just Madrama, just Mliagonja. We'll have Mr. Doku, then we'll go back to Barbara.
Thank you very much, Chairperson. I'd like first to thank the team for a job well done. My comments are actually on the rules, but they are not on specific rules because they deal with the kind of mediation that is envisaged in the rules. Now, if you look at the pretrial rules, civil procedure rules now, it's supposed to enhance discovery of facts. And mediation is supposed to take place after discovery of facts, like the admissions, interrogatories, documents, and even witness statements. Now, in Singapore, this has led to increased settlement because of evaluative mediation. And my concern is in the area of evaluative mediation because it seems we are more focused on facilitative mediation. Now, I want senior counsel to elaborate on that. I think even in America, the rate of fact discovery is very high, the practice. So the rate of settlement is very high. In Singapore, it is over 80% of civil suits filed, and they conduct evaluative mediation by the registrars. I do not know how far these rules can help us to have a piece of evaluative mediation. Then I also looked at the rules in terms of the accreditation of mediators. It looks like the parties would have to choose from a pool on this court annexed mediation. But I was concerned about very many situations where the parties on their own want a particular mediator who may not be necessarily a court accredited mediator. And how can we accommodate that situation where they say we want so and so, not maybe even not a lawyer to mediate our and to ask for timelines, because the court annexed mediation is bound by time. I also want some comments about that. Thank you.
Thank you, my lord. Just Mliagonja.
Thank you, my Lord Chair, and thank you, Mr. Gimara, for the presentation. I am looking at the functions of the Judiciary ADR Committee. The first thing that struck me is where it says accredit mediation training institutions, mediators, and mediation courses. As a council, law council, we ran into problems with the National Council for Higher Education about a provision in the Advocates Act that says we shall be responsible, that the Committee on Legal Education and Training shall be responsible for accrediting courses for advocates. National Council for Higher Education says no, that is their role, and therefore in the accreditation of universities we are running into problems because of the provision in the National Council for Higher Education, the Universities and Other Tertiary Institutions Act. So when you put it here and say that this committee, ADR, shall be responsible for accrediting institutions, I think it may be in conflict with that provision. So we need to look at it carefully. As Law Council, we are thinking that in the amendment of the Advocates Act, we shall exclude ourselves from that act and say this is a course for professionals, the others are tertiary institutions. Should we generally be controlled by the National Council? Because many times we don't agree on which institution should be accredited. So you are likely to run into issues with this. Then when I look at the functions, I also see that there are too many. The functions of the Judiciary ADR Committee. And some of them look to me like micromanaging processes that they are not supposed to manage. I think this committee should mostly be at the level of what are the policies, what are the important things that the committee should look at. Because in each of the courts we will have registries, not so, and registrars. But some of the functions you have put here are functions of registrars. So we need to sieve this and have less functions of the committee. And I think that also goes for when you say in Rule 10, responsibilities of the judicial officer in charge of mediation. Is this judicial officer a registrar, or is it a magistrate? Or when we say judicial officer, is it the judicial officer in the Constitution who would then either be a registrar or a judge? And if you give them all these roles, I don't know whether they can really manage all these responsibilities for one person. If it was a whole registry, I would understand. But responsibilities of judicial officer in charge of mediation, I think these are still too many. Then, of course, there are some areas where we have put things, for instance, responsibilities of a mediator, and for instance, in 12(1)(d), to treat parties equally. Isn't that one of the principles in the Code of Conduct? Impartiality. So in some places you have things that are supposed to be in the Code of Conduct, but we have put them here in the rules. I think we should distinguish between them. Those are some of the things that I thought. There are many more, but I can't keep on talking. I'll let
Thank you.
others also.
Thank you very much.
Thank you very much.
My Lord. Those of you who came in a little later, we are looking at the rules first, making some comments, and we have 4 people already lined up. Your Worship, Edoku.
Thank you very much, Chair and the presenter, Senior Counsel. One comment I had was on the accreditation as well. Chair, as you're aware, that the Judicial Training Institute regulations are being developed, and one of the proposals that the National Council for Higher Education accredits the courses that will be undertaken by the Judicial Training Institute. So this could be one of them, mediation, for example, and that will be aligned by to the Universities and Other Tertiary Institutions Act, as Justice Muyagonja said. The other is on Rule 7.2, that is on the composition. If you look at Rule 4, the secretary, the registrar in charge of mediation is the secretary to the committee. but this registrar is not one of the committee members in the composition. So I propose that the registrar responsible for mediation is a member under Rule 7.2. That will be sub rules or paragraph F, new paragraph F, and then the renumbering can be made accordingly. Then the last one, just general drafting issues that can be polished. Thank you, Chair.
Thank you very much, Your Worship. Barbara Kiley.
Thank you, my Lord. Good morning to everyone. My comments would mainly be restricted to the rules. The first is on the interpretation of alternative dispute resolution. I think in that description, we may have left out a couple of processes that are actually mentioned in the Constitution, especially if you look at Article 126. So perhaps it may be important to include the reference there. The second comment would be, there is a section in the rules that makes mention of payment to mediators and their fees, and parties being restricted from the payment of any mediator's fees. I think it would be important to note that there are instances where the court may order for the payment of fees, especially where a party has frustrated the process. That would be under Rule 48 on the remuneration. So perhaps that's something you may want to consider amending to include a comment on where the court otherwise orders on the payment of the mediator's fees, especially following a frustration. Thank you. That's it.
Thank you very much. I think we'll give it to Emeritus and other members of the committee if they have an intervention, but we'll start. Just Oscar, you don't want to miss this. Okay, let's have you.
Yeah, sorry for being the late fifth contributor. Now, two things. And the first one, I think, is one for perhaps it's an editorial issue. If you look at the table of contents, it looks like there's a misalignment of the sections in terms of what each section is supposed to be handling. Just by way of example, if you go to Rule 23, it talks about scheduling of mediation sessions. But when you go to Rule 23, it actually relates to non-compliance. I suspect that there must have been a misalignment of the rules. So you should pay attention. I think that should be paid attention to. And then very quickly, number 2, on non-compliance, I see that it provides for a party that is who doesn't comply with any of the mediator's directions and fails to attend sessions and etc., or engages in deliberate misconduct, may be charged for contempt of court and dealt with in the manner provided for in these rules. I've looked ahead and I don't see the manner in any other, sanction. I think that possibly could be addressed. My other question would be then, is the mediator being given powers to pass this sanction of contempt of court because he's a court-appointed mediator, or is this then perhaps referred to the substantive judge? Okay.
Thank you. We'll take those 5. Allow him to answer, then we'll take the next after.
My Lord, Chair, thank you so much for I would like to appreciate the comments from the audience. They've been very, very good comments. The first one was at what extent, how far can the rules help us have evaluative mediation, or to what extent do they provide for that? Of course, under the Civil Procedure Amendment of 2019, there is a place for the registrar to manage scheduling, and if they can help with the facts. If the mediation needs a discovery of facts, we are thinking that at that stage, the registrar should be able to make that determination and guide. But where discovery of facts is not needed, then it has to go straight for mediation. But to what extent do the rate of settlement definitely is very high when it is evaluative, and my Lord Justice Madrama, you are very correct in that. I would like to add that we need to look at court annexed mediation generally as evaluative mediation, whichever way you look at it. And in as much as we have been heavy on facilitative mediation, including the training, but moving forward, you need to think about court annexed mediation as evaluative mediation. That is why the presence of, retired judges in this exercise is very critical, because they bring a certain aura. They also ask certain questions that none of the parties or even their lawyers would have looked at. So it is anchored because the way it is anchored is that the court in itself may at any stage refer a matter to mediation. But of course, the understanding is that you can do that when the processes that can aid a quick mediation of that matter they are concluded. And then, of course, this will require a lot of agility by the registrars to marry the processes in civil procedure, such as discovery of facts, and bring it to mediation. So it's going to require a lot of realignment. But I think let's speak about court annexed mediation as largely evaluative as opposed to facilitative in terms of understanding. That's why we are saying even the mediator competence should now be a matter of concern, because honestly, I don't know if you have not been updated in the happenings in commercial court. I don't know how you are going to mediate those matters when you are green completely in commercial law. It's going to be very, very difficult. Because what I have found out that in some of these mediation, you will pick an authority and put it on the table and say, but counsel and the parties, have you seen this decision? And they say, maybe not. I say, maybe let's step out. It's not a long one. Let's give each other a break, go to the other room, go to the other room. These are 2 copies, read, and then we come. Then when they come back, they say, oh, I think that we had not addressed our minds. Let's now go and think about the settlement. And we return next time with some proposals. So that is evaluative. And that evaluative mediation is very helpful. So you raise a very interesting point about the right of parties to choose a mediator that is not accredited. I think that's an important point. Chair, I think we need to think about it and include it. It's a valid one, because the choice of a party to choose a mediator must be respected. So I think that's a very positive intervention. Same with Justice Muliagonja. I think most of the things you raise, it's advisory to be looked at. We have to look at that word accreditation, but also again on the committees, and maybe think about policy. I think most of this is feedback that needs to be taken into consideration, including moving the principle in 12.1d into Code of Conduct. I think that's the same point His Worship John Edok raises, but I think John is saying, His Worship John is saying that JTI has to be accredited, but we need to look at that, whether we need for this course that accreditation in the terms that JTI is asking the National Council of Higher Education to accredit. I think we will study that in light of the guidance that Justice Muliagonja has given. Barbara, I think that's important. We can add that word to make it broader. I think the broader the better. Justice Kihika, I think, yes, the table of contents will be aligned. I think after this meeting, the rules normally go to first Parliamentary Council to then do the fine alignment, but we will make this point to be so that it's catered for. Contempt is not the mediator you refer. Based on the certificate of non-compliance is one of the available options that the judge has. The matter is referred to them. Yeah, and I think the rules make that clear. Thank you.
Thank you very much, and we welcome the online audience. We are with you. After this round of questions, we'll come to you as well if you can note them down. And I think our coordinator with the online audience will highlight them. Just Luswata, you had a question. Just Muviru, PJ Emeritus 3. I see a hand, but I don't see a face. Mm-hmm. Yes, you will tell us who you are. I see your hand. I don't see your face. And is there anybody else? We are on the rules and we are finalizing. Okay, let's take those. Okay. Two ladies afterwards. Just Luswata is going to start. Just Moviru, then the backbenchers.
Thank you, Chair. Just a few comments on the rules. Maybe rule number 5 is a bit misleading. The heading is a bit misleading. When you look at, it's talking about pre-trial mediation, but 5.2 actually talks about mediation during hearing. So you may need to look at that heading. When you look at the functions of the committee, that is rule number 9, and Justice Irene did comment, she thought there are too many. I think so too. But at the end of it all, at 9.2, you say in the absence of the committee, one judicial officer then takes over all those, so many powers. Isn't that giving too much power to one person? Quickly to rule 12. I think issues of conflict of interest should come here, maybe as a 12.3. Once somebody discovers they may have a conflict of interest, they should stand down and it should be clear. I think it should be in the rules. It could be repeated in the code of conduct, but I don't know if it's anywhere, included anywhere. You've explained contempt, but I had a bit of some reservation. Mediation is something that people come into, you know, there's a lot of consensus and goodwill and you know, the good vibes. Should we now start sanctioning by contempt on some of these misdeeds? Isn't it too severe? And it will kill the spirit. I'm happy to know that the language has been opened up in mediations. Personally, I just switch language. Immediately people sit before me and you can see how the body language changes when the judicial officer is talking to them in the language they understand. So we should, when we are training, mediators should be told that you have these powers, because some might fear that we are in a court premises. No. Then I looked at Rule 31. It appears, 31.1 appears to be contradictory to 19.3. 31.1 seems to limit the people who will attend the mediation, yet 19 seems to say, bring anyone you think is relevant to the mediation. So we need to bring those in conformity with each other. And lastly, I think that was all I had to say.
Thank you. We'll go to Justice Muviru, then Justice Bamwine, Emeritus.
Thank you very much, my Lord Chair. I have 5 comments. I'll be brief. In the proposal for evaluative mediation is something we are discussing at the Commercial Division, but we are proposing a structured process. Our suggestion is we begin at the level of facts discovery handled by the registrar. Then we go into facilitative mediation, which is handled by accredited mediators who are not judicial officers. If it fails at that level, then we escalate it to evaluative mediation, which goes before a retired or serving judicial officer. The idea we have is that from this point going into litigation, there ought to be consequences so that we deter people who sit out the process just to go through the motions without serious discussion. If you have an opinion expressed by a judicial officer, serving or retired, or a suggestion for compromise that is reasonable and it is rejected unreasonably, if the matter goes to trial and the outcome is similar to what was proposed and there is no reasonable justification for declining to adopt the proposal of the mediator, then there should be cost implication to that outcome, so that if there's no reasonable ground for rejecting that opinion, proposal, suggestion, and you win the litigation, you don't get costs. Or if you are obstinate about this and you lose, and there was no reason for not accepting the proposal, rather, if you win and the other party can also be penalized by an increment of perhaps 30% in addition to the usual costs of litigation, so that people take it seriously. You don't unreasonably reject proposals with the hope of proceeding to litigation without bearing the costs of that decision. That is the suggestion we are making, the discussion that is going on at the commercial division, which, if it is accepted by the committee, perhaps can also be reflected in the rules, so that we have a structured process well laid out with what goes on at each stage of the process. Then the second comment I have is about the role of an advocate in mediation. We've seen advocates transforming mediation into some kind of adversarial process. It is a training's need, perhaps, but before we go into training, these rules could give some guidelines. Their role is facilitative, is to advise, is to perhaps at the end of it draft the outcome, the agreement. These roles should be specified so that they know there is a distinction between their role as an advocate in litigation and their role as mediator, rather as a representative, a legal representative in a mediation process. My suggestion is that we should spell out these roles very clearly to the advocates, that they don't appear before a mediator as litigators or adversarial representatives, but they are part of a process for finding solutions to the problem. The roles change. That takes me to the third. One of the reasons we don't have cooperation or support from the bar, and on certain occasions you think some of them are out to frustrate the entire process, is the issue of remuneration. We need to address the remuneration of advocates who are involved in mediation, just as we've done for mediators. My suggestion here is that we incorporate in these rules some guidelines to mediators on how they can facilitate an agreement on costs and remuneration of advocates agreed upon even before the process begins, or perhaps as part of the process, depending on the circumstances, so that there is a clear indication of what the expectation is at the end of the process. And this acrimony that comes afterwards does not arise at all. The other comment I have, the fourth one, is about complaints processes. If a person is dissatisfied with the conduct of a mediator who is not a judicial officer subject to the Judicial Code of Conduct, how do we deal with those complaints of misconduct by mediators who are not judicial officers, who cannot be disciplined under that code? So we need to have a complaints process, and also have spelled out sanctions for those complaints that come up against mediators, complaints of misconduct. I think that was the fifth one. I think that covers it. If I recall, I'll perhaps be given opportunity to raise it at a later
Thank you,
stage.
Justice Mumbiru. PJ Emeritus.
Thank you so much, Lord Chair. 2 points. I think the first one is not a point, but to appreciate the committee that processed this draft. It's a job well done, really, come to think of it. Senior Counsel, in your presentation, you highlighted some objectives of the rules, but they don't appear in the draft I have here. I thought it would be good to include them in the draft itself, or in the rules. Of course, the first one, which you mentioned, was to promote uniformity and consistency. Whether you are in Mbale, whether you are in Mbarara, we should be doing things uniformly, or trying to do things uniformly. The other one relates to the report of the mediator. And that takes us to Rule 35. What bothers me, even as a mediator, is what to put in that report as reason for failure of the mediation. Do I disclose that the defendant was very stubborn and or the plaintiff was inconsiderate? My fear is that it may bias the trial judge. So how do we, yes, it may, do we disclose it as it is, that things failed because of A, B, C, and D? I don't know. My problem is that it is, you seem to mention that Form 9 takes care of that, but I don't have it myself. I didn't get Form 9, what I got, so I don't know what is there. I think mediators would wish to be helped to know that one.
Thank you. Thank you very much, PJ. There were 3 people. The gentleman first. Your hand is up. Maybe you just tell us your name for those of us who can't see you properly.
Thank you, Your Lordship. My name is Patson Wilbrod Arnaitwe. First, I would like to add my voice and appreciate the committee for these rules. I do have a couple points to raise, one of them being the title of the rules itself. When you say Judicature Court Annexed Mediation rules, the presupposition is that what is contained in these rules only deal with court annexed mediation. But when you look at what is provided for, it also extends to private mediation, particularly when you look at Rule 4, pre-litigation mediation. Unfortunately, the rules only stop at a few elements of private mediation without addressing that, completely. So what we have is the rules that are more skewed to court annexed mediation with some elements of private mediation but not fully addressed. So maybe either the title changes to court annexed mediation and all matters within the rules address only court annexed mediation, or the title changes and also the rules address other matters that are not court annexed. For instance, when you talk about pre-litigation mediation under Regulation 4, you don't have a lot of detail to govern mediation before court, and yet all other matters have been addressed. The second aspect I would want to address is party autonomy. Some of the aspects that were raised as to why mediation failed previously was the fact that that mandatory mediation clogged party autonomy in the process. What I see with contempt, with most of the regulations that have been provided for, lack that consensual aspect that is required in mediation. You would expect possibly even parties should agree to the application of these rules. I saw among the rules signing of confidentiality, but we'd want to ensure that parties have agreed that they'll be bound by these rules at the beginning of the mediation process, but also to ensure that the powers of the registrar and all other officials in the rules are actually managed to give parties control and the flexibility that is required to ensure that the process is legitimate, is owned by the parties, and protect that principle of party autonomy. Those are the two aspects that I had to raise.
Thank you. Thank you very much. Now we go to your neighbors, the ladies.
Good morning. Thank you so much. My name is Nora Kagwa, and I'm with ICAMEC. Just to add to what Patson has said, as an institution that offers mediation, my experience has been that parties are more inclined to mediate when they believe it's their idea. My worry with certain aspects of these rules is that if parties start to feel that they're being forced into the process, they will start to fight it, which was the case that we saw before. I want to highlight the need for flexibility of the process. I worry that certain aspects of these rules takes that flexibility principle out of the whole mediation process. So to the committee, I appreciate your efforts. I would just wish to recommend that you allow the parties the autonomy to decide on how the process is going to be handled, as well as the mediator. Thank you.
Thank you very much. The other lady.
Thank you, my lord. My name is Lisbeth Komujuningabirano from the Electricity Regulatory Authority. I thank the team that has put the draft regulations in place and all the comments. I think we've really had so many comments on this. Mine is just the law under which the rules are brought. We are looking at Section 41 of the Judicature Act, but that section doesn't really relate to mediation. So I thought we should look into that to make sure that the rules really have a good backing of the primary law. My lord, I also wanted to add on to what Patson mentioned in terms of the contents and the objectives, which also feed into the applications, because the mediation proceedings, if we are going to consider pre-litigation, then the trial stage and appellate, we expect that the circumstances will differ and the rules will also be different. How you get to mediation will be different. So what I would propose would be that at least we have a section on how you move into these proceedings and then what you do when you get there. We will have clients. For example, these rules, we assume that the beneficiaries will be the everyday people who fear court, who fear lawyers, who fear judges. They fear anyone that is associated with court. And when they appear before a mediator, they say, I cannot talk. My lawyer should talk. And my lord, you must agree that the 60 days within which the mediation should be concluded is likely not enough to change the attitude of the person you want to benefit from these proceedings. So I think we can find a way to have the litigants and the beneficiaries to own these rules so that they benefit. Thank you.
Thank you very much. Finally, somebody behind the camera.
Thank you, my Lord Chair. My name is Ivan Engoru. I'm representing the Dean of Law of Makerere University. My Lord Chair, My comment is in respect to Regulation 24. If you read the title, it says accreditation and qualification of mediators. But the content of that regulation, in my view, focuses on accreditation, and there is barely nothing to do with qualification. Perhaps, my Lord Chair, to address the controversy which has been raised by my Lord Justice Mulangonja on the legalese of the committee accrediting mediators. First, my proposal is that we need to be clear on what the qualification is for someone to access that register of mediators to be kept by the registrar. I think that could be one way of avoiding, some kind of contestation among institutions of government. If we drew from the Magistrates Courts Act, it says the Chief Magistrate shall keep a register of assessors. But in there, it clarifies who qualifies to be an assessor and who does not. I think going forward, in the meantime, Senior Counsel, you could consider redrafting Regulation 24 so that it's not only about accreditation, but also clearly provides for qualification on who is eligible to be appointed a mediator. Thank you very much, my Lord Chair.
Thank you very much. We are going to allow our presenter to respond to those. Then we'll go to the online audience, and then we'll go and consider all the other rules together. But Justice Mulangonja wants to intervene before.
Who talks too much according to the judges of the appellate courts? Proposals of mediator. Someone talked about the robbing the parties of their flexibility, and I also thought about it when I heard that in some instances there are proposals for settlement made by the mediator. I think that a mediator can draw out what are possible proposals, but I do not think that it is right for the mediator to make a proposal about how a matter should be settled. So if it is anywhere in the rules, it should not be there, because it is robbing the parties of the independence of reaching a win-win situation. A win-win situation is one where the parties feel, this is ours, we are the ones who have done this, we proposed this, we proposed the other. That is all, my Lord. Thank you.
Thank you. Over to the presenter. But on the other matter where the Justices of Appeal have made a ruling, it's not yet on appeal, so it stands.
Thank you again for those comments. I know it's a committee that is receiving it, and some of the committee members will intervene or consider them at a later stage. But I can respond to those that I'm able to. I think for Justice Luswata, yours I think are proposals for improvement, alignment, and then the issue that that you seem to request the committee to look at again are issues of sanctions, this being a mediation. Sanctions is coming in the context of non-compliance, where you arbitrarily, this is presumed to be a proceeding under the architecture of court. The court has come up with rules. The rules require you to have a mediation, and then the Rules Committee has enacted these rules, and you are just doing everything flagrant. What should happen? At least the whole issue is to encourage, to allow parties attempt mediation, even when it's going to fail, but at least attend to the process. Because I think the understanding is that we all agree it's important, And it's not a power that I think the judge is going to exercise. It should be the very least and very exceptionally. Contempt, even in court itself, I think it's rarely exercised. So I don't think this is going to be the first. But if you go and look at the provisions on non-compliance, this is just one of the very last ones. There are things to do, go back and mediate again. There are costs, and then this is as well put in there. So it is something to debate about, to ponder, but I don't think it is a major one. I think the rest really are received for consideration. Justice Mubiru, you raised a couple of points. Again, to deepen the structured process you are proposing in commercial division is something we should look at and attempt to balance that with what mediation is. I think that is the line we need to create. I think at the earlier stages, evaluation, thinking through it, but you may now need to think whether, if you are going to apply sanction based on an opinion a mediator has issued, whether that is still mediation. Those are some of the structural issues we need. There is something to borrow from that, but also there's something to balance with what mediation is. So that is what I think we need to look at in terms of that. Role of advocates, that has been provided for in details, again in the manner that you have highlighted. The advocates need to understand, and the rules now require that understanding, that it is a party-led process as opposed to an advocate-led process. What you're saying which needs to be done is training beyond the rules, that this role is then understood. I think that is something to do. Remuneration is for mediators. The advocates rule, I recall in 2016, we then worked out an amendment to remuneration of rules. We put some money for mediation, which is about 100,000 shillings per hour for advocates. Now, that is not something then that had been aligned with these rules. It's a discussion that the Law Council can look at whether it's still adequate or whether it needs to be reviewed, taking into consideration the views of stakeholders. But the remuneration that can only be provided by these rules is for the mediators, because that resource is provided for by the judiciary, and the judiciary has already issued, the Chief Justice has issued some guidelines on what the judiciary can pay at the moment. I think the Chief Registrar, you want to speak to that briefly, the current position. I think there is for successful, not successful, and failed mediations. Yeah.
Thank you so much. The current position is that there are rates that apply to the superior courts and for the lower courts. For High Court, Court of Appeal, and Supreme Court, the rate for a successful mediation is 300,000. An unsuccessful mediation a successful mediation in the lower court is 150,000. An unsuccessful mediation in the higher courts is 112,000 shillings. In the lower courts, it is 75,000. A partial mediation in the superior courts is 200,000, and in the lower courts is 100,000. Those are the rates that apply per file, and that is in each of these courts. Thank you.
Yeah, thank you. Just for emphasis, then the rules provide that the Chief Justice shall always determine if that needs to change, but we can't put the rates in these rules because it's administrative, but the power is reserved with the Chief Justice to amend that framework should there be a need, again, on the advice of the committee. PJ Emeritus, you have raised a suggestion which is well taken about objectives. I think this will be put to the committee for consideration. Report of the mediator, I think the key here is not to violate the principles of mediation, but the report is to tell court what has happened. It has succeeded, but now the importance of having this report is as well to ensure that court does not waste time for purposes of the court or the judge to note whether the non-compliance with mediation has been as a result of arbitrariness for them to invoke those consequences of non-compliance. For instance, refer the matter back for mediation with a stern warning that this is a court process, please take mediation seriously, or costs for the one who frustrates mediation. So I think your report of the mediator should enable the judge to make that decision, but not to go into the other matters that are, it is a lot of, and I think a mediator would know what to put in that report. It's a lot of mediator discretion at that stage, but the framework under Form 9 is just a guidance on that. Yes.
I am understanding where PJ Emeritus is coming from. This report of the mediator, would it be seen by a trial judge?
Yeah, because you see, it is not, when you look at Form 9, the report is just, I having been appointed, I've conducted the mediation between the parties, they have reached settlement, and you attach the settlement agreement, you invite the judicial officers to action that. Or partial, meaning that there are issues that the judge would like to determine now. They say, okay, on this matter, we have agreed. On that one, place it before the judge. So you narrow the issues. So the report of the mediator is to give that guidance to the court. But there is a fine line, and that has to be out of mediator discretion. Going back to the principles, there are some matters you know that you don't indicate in that report. And my view is that a well-trained mediator would know what to do on that. Yeah.
Maybe just to allay her fears, because you see, these files are kept separate.
Yes.
But there's no danger in the judicial officer seeing just the report.
Yes,
they
exactly.
They should not be privy to everything else.
Well said.
But they need to see so that they know how to conduct, maybe if it was a partial settlement, for example.
Yeah. Thank you. Mr. Rinaitwe, who is now taking the lead of teaching LDC students ADR, thank you for coming. Party autonomy is provided for here. But like we said, when we are doing these rules, we are thinking systems. You have a situation where a matter is filed in court. How do you handle it with the court? You have been persuaded that mediation is a good thing to try. We have done it, and we've seen some success results. We are seeing parties who had filed matters just out of anger. You know, they have cooled down. At mediation, they are saying that's no longer a big issue. Let's close the matter and move on. And a good mediator is enabling that. So ordinarily, if the mediators are trained, and there's a system of training them, and they have credibility, most of the mediators, and we have seen this from court annexed mediators, I don't know how many were rejected by parties. Is there anyone here who was rejected by the parties? To just say we don't want you as a mediator. Yeah? You can see that the level of acceptability, it's trust that these people have been trained. Some of them are retired judges with very sound credibility. So the parties will accept, but not to lose the principle of autonomy. You need to go back to read Rule 16.4 and look at 5 and 6. We say, in as much as the court appoints you, you, the party, can decline, the mediator can decline himself, but also the parties can say, no, we want another mediator. And the rules emphasize, again, in respect to the principle of autonomy, that the choice of the parties on who to mediate will override any other appointments by the court. So it is provided for. But we need to balance that with the system instead of leaving parties. Remember, they are coming at a place when, you know, the lawyers are not pushing stuff. 2013 legal framework, nobody is pushing. But when you have the capital that I have given you a mediator to start with, you have the choice either to go by the mediator or to say we don't want this mediator, we would like the other one. But the rules say that when you make that choice, that decision is overriding. So we have respected that autonomy, but while at the same time enabling the system to function, allow the appointment to go on, exercise the right to reject if you wish so, to do so. But like I would say that if these mediators are well trained, you will find that many of them are accepted by the parties. I think Nora as well, that does, and Liz, I think the Judicature Act in that respect is just to mandate the Rules Committee to make these rules. It should be looked at from that angle. Ivan, I think that will be looked at to again look at how you marry accreditation and that. I think, my Lord, I don't know if there are members of the committee who want to supplement, but in my view, those were the main issues. Yes, Patson, Mr. Knight raises the issue of the naming of the rule, court annexed mediation. I think those who are in Lumumba like me, you understand the word annex much more than many people. But the naming of court annexed mediation is just that this is a court process. It is attached to the court process. Now, the pre-trial is de-emphasized because we are giving the parties the choice. If they would like the courts to help them to enforce, they provide that by agreement, and you can come to court. In essence, today, in my law firm, if I want to craft a mediation dispute resolution mechanism, I say we'll appoint a mediator. I can even put a court annexed mediator or any other mediator, but say that in the event of after the mediator has finished, he will file whatever we have agreed should be filed in court for enforcement. So we are giving opportunity for such agreements to then lend themselves to the process of court. But it is your mediation, you manage it, only you come at the tail end for purposes of enforcement if you want the court to lend you its enforcement mechanism. So that's why we are looking at it from that angle. And we have not emphasized that detail because this is really a court annexed mediation and it should remain in that way. Thankfully, the ADR policy is speaking to mediation in a broader way, and I think they're also going to have mediation practice groups that will be speaking to mediation broadly beyond the court annexed mediation. So I think that's it.
Thank you. Thank you. Before we transition to the online audience, Councillor Robina Shonubi.
Thank you, my Lord. I just wanted to speak as a mediator who's been listening to the input of various participants. For example, impartiality. I just find my name on a cause list with with the parties, and we meet each other for the first time. And I think immediately you can see neutrality and impartiality just coming because of the way the parties are assigned to a certain mediator. And I think that's a good thing. Although some people have come and asked that I mediate a matter, but at the registry they haven't allowed that. I don't know why. And I think it's better for seemingly random, allocation, because then everybody is starting on a clean slate. The only people I know in most of my mediations are probably the lawyers once in a while, but in most cases I don't know anybody else in the room apart from the clerk. Justice Mubiru kind of helped me address something that's been bothering me, because when the parties are unreasonable and they reject what their counterpart is saying, and it's clearly an unreasonable refusal, what we do, fortunately this normally comes out when we've agreed on a few clauses, and maybe the the defendant or the plaintiff is disappointed that things seem to be going so well. So they put on an adamant stance. And so we get into a partial mediation settlement, and we forward the outstanding matters to go for scheduling and litigation. And I think what the judge has said is true, that you may find that what the other party rejected is exactly what the judge will recommend or decide on. And I think that's something that I'll be glad to see, because you can see something slipping away, and you don't have the authority or power to say, no, why don't you change that? And then if it goes to before the judge, then they're going to actually agree with what the other party had rejected. And then also for these people who think that, when parties come to mediation or even to court, that, that they're just a bunch of people who don't really know their rights, I think that is wrong. It's very important to respect the parties. By the time you have a matter that can actually go into a process, whether it's litigation or mediation, it means you have a stake. That stake could be land, it could be property, it could be children, it could be money, and you want to see this matter resolved. So this business of saying that, oh, these are just simple people off the street who are afraid of judges. No, one of the reasons why the court has invested 50 hours of training, for example, for maybe, I don't know, were we 60 people or so, is so that we know how to address these people. From the second they walk into that courtroom or mediation room, the way we seat them, the way we prioritize the parties, so that within the first 15 minutes, they know my matter is being handled for real. It's not just a joke. It's not what I used to think about courtrooms. And so I think when we say that mediators are being trained by the court, it's actually equipped us to be able to address many of these fallacies that, the parties are scared, they don't know what they want, they're relying on somebody else. No, once within the first 5-10 minutes, they've understood the procedure, and they actually hear themselves articulating what they really felt or how they were hurt or what rights were infringed, you find that the mediation goes on without the mediator even prompting them, once you have a good start. So I wouldn't worry about that, thinking that their rights they won't really have a fair trial, or they won't have a fair day in court just because they're in a certain building. They know their opportunity has come, and once the mediator gives them that ball, they'll run with it. Thank you.
Thank you very much. Thank you for those comments. Could we now transition to online and see if there are any comments there? Thereafter, we'll move to the rest of the rules, the regulations. Master of Ceremonies, I thought you were the one controlling the online somewhere else. Okay.
So the rest will tackle them and take off. You can receive the other room generally because they are near each other.
So, Master of Ceremony, you can help us read.
Yes, my Lord, I managed to capture some, and I can read off my phone. The first comment was coming from Catherine Vainomugisha, who is a guest, and was commenting on Rule 14, the role of advocates. And she says, There should be a deliberate effort to get the law training institutions to have ADR as one of the core subjects under their curriculum, not just an elective subject. At the same time, the judiciary outreach programs should also target the population to raise their awareness about ADR, particularly court annexed mediation. She also comments on Rule 16, Sub-Rule 4, the appointment of a mediator. Does the appointed mediator need to give reasons for declining the appointment? That was the question. Do the parties, or does the party need to give reasons for rejecting the mediator that has been appointed by court? She further comments on Rule 16, 7. Is the date on which an accredited mediator's name was added to the register of accredited mediators the best guide to allocation of cases? What about areas of interest, specialization? She also adds about Rule 17, 1 and 2, notification of referral of mediation. At what point in time does the mediator access the file? Is it electronically sent to the mediator together with the notice of appointment, or does the mediator have to access the hard copy file? If so, at what point in time? Are mediators' rooms provided, or the mediators have to wait until room is created? She further talks about Rule 19, participation in mediation sessions. Sub-Rule 2A and B, letter of authorization. Will the letter of authorization have the same force as powers of attorney? Rule 19, 4A and Rule 31, 6. If a party brings along someone totally new towards the conclusion of the mediation, must that person sign the confidentiality and inadmissibility agreement? Further, on Rule 19, 4B and Rule 36, how is the mediator going to enforce the requirement not to use any electronic device to record the mediation sessions? On Rule 22, scheduling of mediation sessions, does judiciary have sufficient space for the physical mediation sessions, or are the majority of the sessions going to be held virtually? Rule 28, the venue and time of conducting mediation. 28.3, in relation to mediation session conducted at the mediator's offices. What happens if the arrangements with court for security aren't yielding fruit and the court lacks space for mediation sessions? Talks further about Rule 23, non-compliance. 23.2, misconduct may be charged for contempt of court and dealt with in the manner provided for in the rules. What do the rules provide exactly on how someone can be charged with contempt of court? There should be clear, specific guidance on this matter to ensure that this matter is correctly handled. We get to Rule 23.4. A party fails to comply. What exactly is several times before a certificate of non-compliance is issued? 2 and 3 times, or you must keep scheduling dates until the 60 days lapse. The next is on the 2013 rules, private mediation. The 2013 rules provide for parties agreeing to to private mediation upon consultation of the registrar or the judicial officer in charge of mediation. This seems to have been dropped in the 2025 rules, yet it could have enabled parties to choose mediators who may not be court-accredited mediators, who are specialized in the area under dispute, and would have encouraged the growth of private mediation and contributed to case backlog clearance. And then lastly, we have from West Nile Mediation Center. First comment is under Rule 7 and suggests that a provision for representatives of court-accredited mediators and training institutions suggests that there should be a provision for that. Number 2, that parties who decline an appointment of a mediator should provide a reason. And number 3, that Rule 7 should provide for the qualifications of a mediator. So far, that's what we have online. My Lord, I beg to
Thank you. Thank
back.
you very much. Thank you very much, online audience, for being very, very attentive. And we'll allow the presenter to respond to them. Then we move on to the rest of the documents.
Catherine, who is online, raised a couple of issues. I just pick the main ones. I think most of them are suggestions, but I think some of the issues that you raised need to be looked at in terms of the accreditation, what happens to those who were accredited in 2013. I think most of them were then accredited under the pilot scheme, but it is important that they draw their attention to the accrediting office, and that I think has been handled administratively. Letter of authorization and the need for you again to do a confidentiality and inadmissibility statement. I think that is important because it's always critical that those documents are signed. Part of the, I think somebody raised it earlier, how do you consent to the mediation? Part of it is to adapt these forms and ask the parties, even when court has nominated you, as they sign that confidentiality and inadmissibility statement, to put a proviso there, that the provision there, that they agree to the mediation and the outcomes that shall arise from it. So it's always important, and normally what I do before I do a mediation, for me that's a very critical statement for parties to sign, because then it ensures that their willingness to accept me as a mediator has come from them. Even when the nomination has been coming from court, I have been requiring them to sign that. But just like I think the Chief Registrar said earlier in the discussion we are having, it is important that even when court has appointed you as a mediator, the gravitas you bring to the mediation is important. And that's why we normally say in your opening as a mediator, it will determine whether the parties buy into you or not. So you, in addition to being appointed by the court, you have to sell yourself in the first 1 or 2 minutes through your credibility, why you, even when appointed by court, you have to tell them why, for instance, you like the subject of mediation. You have to break the ice, such that even those who have come with the intention to frustrate or walk away out of mediation are persuaded by your persona to give it a try. So your closing must be, let's give it a try. I'm sure we'll get somewhere. Should we? Yes. And then you proceed. So a lot of the skills in mediation, even when these things we say as icebergs, as blockages, are things that mediators need to always equip themselves with. Things that look difficult, you need to always have skills to break the ice. I think the other issue, I think, Catherine, a lot of your matters will be looked at, but the one that I wanted to say, yes, you raised about 60 days, whether how many times you should schedule again, that is a detail. But what amounts to non-compliance is at 60 days you have done everything reasonably possible as a mediator, and the person has frustrated the mediation, then that is something that you then capture in terms of the frustration. But use the 60 days that the rules provide to try and get the parties to talk. Yeah, the point I think has been made about us allowing private mediation where parties want to do that. I think that we have said we are going to look into that and consider it. Chair, I think the proposals from West Nile Mediation are proposals that will be looked at. Yeah.
Thank you very much for that response, and we thank them for the proposals made. You have
yes, madam.
One more?
Two more.
Okay.
They have just come in. My Lord, that is Komjuni Olivia. The arrangement of rules provides for principles of mediation, basically under Rules 46. But when you read the entire draft, you can't find the principles anywhere. I've taken keen note on misarrangement of numbers, but still failed to trace the principles of mediations. My name is Komjuni Olivia, court-accredited mediator at Kajansi Chief Magistrates Court. And George Bamugemerire, I have found some people flashing business cards bearing title of mediator and inviting parties to contact them for help. Could the presenter guide? Thank you, my Lord.
Thank you very much, Olivia, and thank you very much, George, for raising those. We'll allow Emeritus to answer.
The first one, the principles, we have provided for them in the Code of Conduct in details. So, Olivia, those principles, yeah, you will struggle to find them in the rules because they're in the Code of Conduct now, as opposed to the original framework where they are in the mediation rules. George raises an issue of flashing business cards bearing the title of the mediator and inviting them to contact them for help. I think that is beyond the court-annexed mediation. That is perhaps something that the ministry, if they so wish to regulate in the new law to operationalize the ADR policy, would like to attend to. But I would think if it bears court-accredited mediator, then of course that comes under our jurisdiction for, one, to find out, two, and then determine whether there is a process for the parties to invite. I think the system we are creating here is for courts to refer you to the mediators. So this would be a strange one for court-annexed mediators. Yeah. That it may be a village mediator, I don't, and that is, there's no problem with that. Mm-hmm. Yeah.
Thank you very much, Emeritus. It's a developing area, mediation, and so on. So as we go along, if you have any other on the rules, any other comments, additions, we can receive them either online or, but for now, allow me to change gears and we go and look at the rest of the documents. If there are any comments on the accreditation of training institutions, accreditation of mediators, and the code of conduct, which were also presented by our presenter. If we have any comments on those, we are taking them all together omnibus. Yes, can I have some hands of people who may have? I see Jasmine Gonja. I see the others are also questions. No, but he made the presentation. So he was presenting about those documents. Yeah. Okay, I see.
But you can also share them, then they can keep sharing the
Okay.
comments later for those who didn't get.
Okay. Yes, I've been guided. The documents can be availed afterwards, and then you could give your input in case the presentation was not detailed enough. So we'll have you, and then I see somebody at the back. Were there two hands? Yes, the two hands at the back. Any other? Okay, let's start with those. Yes, you tell us your name and you ask your question or make your contribution.
My name is Nabukenya Zaina. I'm a mediator at Land Division. Well, as they talked about the issue of remuneration of lawyers during mediation, to my mind came also the idea of fees to the mediators. Those two should be balanced, and yes, because well, the Chief Justice might have given the guide, the starting point, but it's little money. We must acknowledge that. So as they fix the lawyers' remuneration, I think it needs to be balanced with the mediators as well. And then my other point is on the 60 days. I think, in my opinion, it's quite a little time. And then, even if it's maintained, okay, but then the other extension also needs to be limited to maybe another 60 days so that the rule doesn't leave it open. And well, I don't know why the mandatory mediation failed, but I appreciate the fact that mediation in the new rules will pass through a judicial officer, but I think that's quite a lot of work for one person to sieve through, all the judicial officers to sieve through and get work for all the mediators. There needs to be some balancing, as in, well, when mediation was still mandatory, I would see the files come in regularly, unlike right now when a judicial officer who moreover has so many other work to work on has to give us work. Those are my comments.
Thank you, Mediator Nabukenya. Why do I think you spoke for majority of mediators when you mentioned that thing about fees and balancing? So thank you very much. Yes, behind.
Thank you. I would like to really, sorry, my name is Catherine Donovan Chokunda. I'm the Commissioner, Uganda Revenue Authority, Commissioner for Legal Services and Border Affairs. I thank you so much, the committee that has put this work together. I think it's a very good starting point. Whilst the comments that have been made regarding some amendments, I take note that this is really the way to go. Just speaking from the perspective of how many cases we've got that are before the courts and are held up and we're waiting for timelines. So I welcome this, and I'm just wondering about the timelines or whether that has been thought about in terms of after this process and you've made the amendments, what are the timelines like? When could we anticipate this being rolled out so that we can actually get the benefits of what I think is a clearly beneficial way forward in terms of how to deal with disputes? The other reference I would want to make really is indeed remuneration. I suppose really whilst we are looking at, Justice Mubiru recommended the idea of having remuneration thought about for advocates. My suspicion really in terms of how we've been dealing with matters litigation-wise is a lot of advocates would not be very inclined to head towards mediation simply because of the remuneration that they receive and the impact of that. And so when it comes to settlement, and people are looking at what they're going to earn if you're looking at settling at mediation rather than a partial settlement, that has got a significant impact that needs to be addressed. And perhaps it goes back to the entire process in terms of how our advocates are going through the process of, legal practice, where you're taught to advocate and argue in court without really looking at the mediation side of things. And perhaps it really needs to go back to really treating the whole enrollment, people looking at this as the way forward, rather than clogging up courts, and to see the benefits of that without feeling that they are losing out per se on remuneration. So if we gain that balance, I think there'll be a lot less resistance, because then the advocates themselves will be encouraging their clients to take matters into mediation and to look at that as the way forward, to actually look for resolution of matters, disputes, rather than going through the process because of the commercial impact. Thank you.
Thank you, Councillor Chokunda. Was there another hand? Yes. Yes.
Thank you very much, my Lord. And thank you for the team that put this together. I just wanted clarity.
That is Madam Irene Lugaizi from First, is it still First Parliamentary Council?
Yes,
okay.
Yes, it is.
Yes, please go ahead.
I just wanted a bit of clarity. One of us in the room mentioned the anchor from which these rules emanate. When you look at the Interpretation Act, rules stem from principal legislation. And there was mention of a policy. Policy sometimes has administrative and regulatory areas. Now, I've been scanning through, of course, this a cross-reference to Section 41 of the Judicature Act is in error because it's talking about mandamus. So I just wanted clarity, or to understand the thread from which these rules are stemming from. There was an explanation that I didn't quite get about rules being made, and that is where my clarity, this is where I'm seeking clarity.
Thank you, and you're the right person to ask that question. And we'll make sure it is answered. If there is no answer now, we have to find a home for the rules. But just Madrama seems to have the answer or related question. Okay, please go ahead.
Yes, if you look at thank you very much, Chairperson. If you look at the Judicature Act, it has provision for references. Now, references are made by the registrar to arbitration or for trial. But I think the section should be wide enough to include references for mediation. Since it is a consensual thing, you are still anchored in the Judicature Act, not only under the rules made under Section 41 by the Rules Committee for regulating the practice of the court, but also in terms of the Section 26 to 28, 27, 28, which deals with the trial outside the court by other people. But in terms of the particular thing of mediation, I believe the civil procedure rules should be sufficient to accommodate mediation.
Thank you very much. Justice Maria Gonja.
Mine is a wild guess. You know, when you look at Article 126 of the Constitution, it provides for this, provides for mediation. But then if we are basing the rules in Article 126, then it would not be the Judicature mediation. It would be the Constitution, Court Annexed Mediation rules. Just like, I think the ones we had in the commercial court were also Constitution. Judge Bamwine, they were Constitution. So I think instead of having Judicature, we could base them in Article 126, the relevant provision there, and say the Constitution, blah, 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 regulations. Then would be anchored somewhere.
Thank you. Worship Edoku, is it on the same point?
Yes, Chair. Okay. My belief, to answer Madam Irene's question and the question in this room, is that one, these rules can be made by the Rules Committee under the Judicature Act. The only thing here is that I believe Section 41, which was in the previous principal laws, is what is quoted here. We just now need to get in the revised laws of 2023, the exact provisions under which the Rules Committee can make rules under the Judicature. I thank you.
Thank you. The last intervention before I hand over the presenter will be from Barbara. I saw your hand up.
Thank you, my Lord. My comments are on the accreditation guidelines for mediators. Considering that you want to introduce a culture of coaching and mentorship, perhaps the requirement for continuous accreditation would be the hours spent to coach other mediators or mentoring other mediators. I think that would be useful. The other comment would come under the application process itself. What about, because you mentioned this in one of your statements about villages who have expertise in mediation. The current requirements are specific about professional membership. Perhaps you could consider including a clause that would allow for recommendation from recognized or significant members from the community who would then vouch for that particular mediator who doesn't belong to a professional body. And the final comment is under training and education. I'm wondering whether on part 2, because there's part 1 and part 2, whether part 2 is merely a proviso. If it is, I think then it should be drafted as such. Otherwise, it appears as though it is specific to judicial officers only. Thank you.
Thank you very much. And I will hand it over to the presenter to respond to those which can be responded to, and then the others can be forthcoming even after we close. Emeritus.
Thank you. I think mediator, we heard from NAB Kenya Zaina about the need to handle on the issue of 60 days time. I think that time can be extended on good cause, but you would like to have the general rule complied with to the greatest extent possible, that mediations conclude within 60 days.
Madam Zaina, I think the presenter is answering to you, but I see you are...
So the 60 days is little time to conclude, but you don't want to leave the time very unlimited. 60 days, give the mediation your best shot, and if there's ground for you to extend, the rules provide for that. But again, let's remember that the system must inspire public trust. If you're going to have people's cases referred to mediation, then there is a corresponding duty on the mediators to action, because you are selling mediation as being flexible, enabling you to complete matters in time. So you need to lend it that time advantage, as opposed to having the matter stay in courts. But having said that, there is a provision for you to ask for extension of time. On the issue of remuneration, I think that one is administrative. I am sure those who pick such signals have picked the signal, and they will have a discussion and then at an appropriate time attend to it. Chief Registrar, you would like to reply to what Ms. Chokunda has asked. What is the process like from today? When is what path does the process take? until when the rules are ready to be used. What next? Yeah.
So way forward on the rules is that after this validation, the rules are going to be cleaned up with the comments, and then they will go before the joint retreat of the Rules Committee and the Law Reform Committee. When they are further polished and enriched from there, then they will go through the process of gazettement. Once that is done, they will be issued out, and then we will be applying them. That is the way forward on these rules. Thank you.
Thank you. That's what, Catherine, you asked another you made another comment on remuneration of advocates as well. That's still a challenge, but today also the practice of dispute resolution is as well evolving. As practitioners today, you have to think about creative dispute resolution for your client. And in that, you can build value. It's a discussion that you have to discuss with your client. So we need to be, as well as we await this, but I mean, if you have a discussion today on the value that you are going to bring to the client, and you negotiate based on that, it is an evolving thing that today most people must think about how you can resolve disputes creatively, and clients are willing to pay for that. I mean, if he has $10 million locked up in the court system, and you take them and you say, let's go to mediate, we save this, we save that, and save that. Yes. It's a discussion you can have. I have that a lot, and it has worked. I think as advocates, we need to also think around that. How do we resolve disputes creatively, other than just saying we are going to litigate up to Supreme Court, we are going to be in courts for 3-4 years. This one will take you this, will take you that. But clients pay for value, and I think...
just as a point of information, there was, I think it was last year, when we had a mediation session, and the issue of costs for the advocates was actually part of the discussion. Okay, so that became one of the issues to be resolved. And in that way, by way of feedback, actually, there appears to have been, the advocates actually welcomed this whole process, because for the first time, they were seeing their interests being, discussed and being covered in the mediation process. Maybe that is something that we need to think about.
Thank you. On the, I think, Irene, I think both Justice Madram and Justice Muliagonja have attended to that. But of course, the Constitution is the overarching framework for this. But we need to think whether we name them in that manner, or we still go by the Civil Procedure Act and rules, because that is in itself, for instance, the 2019 rules creates a pathway for mediation, a very clear pathway for mediation. And these rules can anchor that. But again, we can, I'm sure that your department will engage with these rules, because, and then we see how much we can do to align that. I think, Barbara, your comments were views, additions to be considered, coaching and mentorship, and those I think will be looked at. My Lord Chair, thank you.
Thank you very much. Thank you very much. Let's give a hand clap to our presenter for ably answering questions, and let's give another round of applause to ourselves for turning up, being attentive, and ensuring this validation is a success. Of course, we should give a hand clap to the online audience. Not only were they there, but they participated actively. So thank you very much. And with that, I would like to hand over to the Master of Ceremonies, and I thank you very much for participating.
Thank you very much, my Lord Chair. And I will request that we also give my Lord Chair a mighty hand clap. Thank you very much. Dear participants, I've been asked to inform you that if you have any additional comments that you would wish to share, hereafter, please, they can be sent to the Chief Registrar by Tuesday, 25th, so that they can be put into consideration. I have two important announcements. The first announcement is that lunch is available and ready. That is not a very nice one. Yes. So we are going to have lunch, and then the second important announcement from the Secretariat is that you will be provided with a modest sitting allowance and fuel refund. Secretariat, by our worship, your worship stand up, people may be looking for where to find this important second announcement. Yes, the Deputy Registrar in charge of ADR will be handling that second aspect. But our lunch will be served where we had our break tea. And so before we break, we shall request that we move here for a group photo. Can I have my teams? Your worship, Zuleika, can we have the teams to arrange for us? And we have a photo. But before we go then for the photo, Daniela, let us do that first. I want to pray for the food that we are going to take, so that after the photo, we just move for the lunch. Lord Father, we thank you for this afternoon. We thank you for the deliberations that have been taking place here. We thank you for this wonderful audience, the participants who have really contributed to this good cause. We thank you for our facilitator. Thank you for the committee that brought all these works together, and equally our online participants. As we come to the close and have the lunch that you have prepared for us, let it be partaken in your good name, and we pray this in the name of Jesus Christ our Lord. Amen.